Hello everyone and welcome to today's Mondac webinar in association with Moody's Private Clients, who will be outlining the US Citizenship Renunciation process and what you need to know to optimize client advocacy. My name is Dan Sampaio and I'm joined by the wonderful Alexander Marino today. Alexander has years of experience in cross-border tax law, estate planning, corporate tax and US expatriation law. In addition to leading the US tax practice group at Moody's Tax Law, Alexander also heads the US renunciation practice, annually representing hundreds of clients worldwide in properly giving up their US citizenship or terminating their US green card status. He regularly speaks on the topic of US renunciation and expatriation in Canada and around the world as one of the foremost experts in this area of law. Now, before I hand over to Alexander to begin today's webinar, a housekeeping item. You can submit questions to Alexander by typing them into the questions pane of the toolbar on the right-hand side of your page, and we do encourage you to send those questions in. It's now my pleasure to hand you over to Alex to begin. Thank you.
Thank you, Dan. I appreciate it, and welcome everybody. Thanks for tuning in, and we'll jump right into the fun. Obviously, renunciation is a topic that 5, 10, 15 years ago, people would sort of whisper in dark corners, and we run one of the largest renunciation practice groups in the world and help about 900 to 1,200 people a year on 6 different continents properly give up their US citizenship, and we have, in many locations, record wait times to renounce. Here in Canada, 1.5 years, 2 years just for the privilege of getting an appointment to renounce is pretty astounding, and that's actually down. But as you probably can imagine, the reason many people are lined up to renounce is the manner in which the US taxes. And that's what we're going to talk about today. We're going to try to, when I do these presentations, the real objective is to fill in misnomers. The internet is full of bad information, not only help tax professionals, but financial advisors better identify issues for their clients and not only protect themselves, but their clients with a lot of these cross-border US issues with expats abroad. So to jump into the fun, again, today we're gonna, from a high level, talk about renouncing US citizenship in the limited time that we have. Just quick, Dan did a wonderful job in reference to the introduction. Moody's is a Canadian tax law firm. We have offices in Toronto, Edmonton, Calgary. I run that US group. We bring up all of our US lawyers and US accountants. We believe in the model where we bring up individuals who are educated, raised, practiced. So like many of you tuning in or many of your clients, I'm a US citizen myself, living in our Calgary, or living in Alberta, working out of our Calgary office. So I feel in much of the same pain you or many of your expat clients do as well in reference to the double taxation problem. We'll skip over the disclaimer, but obviously these slides are high level. Anybody looking for substantive advice, deeper dive into specific situations is always recommended to get proper legal counsel, and we're absolutely willing and able to answer any questions and help along the way in that regard. Just real quick, an overview of, when I do these presentations all over the world before COVID, in reference to outlining the issues of expatriation. This one will be tailored a little bit more towards residents in Canada, Caribbean. We help individuals in Australia, Middle East, Europe, all over the world. But really, why are people renouncing US citizenship? It's the way the US taxes. It's the reporting obligations. It's the double tax that can be generated depending upon whether you're living in a low tax jurisdiction or a high tax jurisdiction. And then, of course, the issues in death. That is the crux of why financially we have thousands of people handing in one of the most coveted passports the world has ever known and willing to pay legal fees and a pricey government fee to boot. Now, whenever somebody's looking to renounce, I always tell them there's 2 hurdles in deciding whether to renounce or not. There's going to be the tax ramifications of keeping or giving up the US citizenship as a US expat or a green card holder. And then there's the life decisions. Now, from a tax perspective, as you probably can imagine, being taxed by one country is always better than being taxed by 2. I always jokingly say you can get that tattooed anywhere on your body and it'll stay true for the rest of your life. Now, when you're looking at it from a tax perspective in reference to giving up the citizenship, as many of you may know, it's not as easy as just sliding the passport under the embassy door. the US, there's State Department, USCIS, Homeland Security, Social Security, obviously tax, immigration. We need to avoid a US exit tax. There's an interview. The culmination of a renunciation is speaking before a vice consular of the United States at a US consulate or embassy between 6 inches of bulletproof glass, and whether that's in Toronto or Tokyo, they write a report which is mailed to the US Attorney General's office. And that US Attorney General employee assigned to that file will approve or deny the renunciation, and then also make a determination under the Reed Amendment as to whether there's a tax avoidance motive and to disbar the individual from the US for life. And we'll talk about the importance of the preparation of that interview. But from a tax perspective, we need to avoid the US exit tax, and the vast majority of clients who are renouncing, and with the Trump policies today that are still in place, it's a very advantageous time for high net worth individuals to plan and avoid the US exit tax. Those rules are sunsetting in January of 2026, and we'll see what happens in November. But from a tax perspective, when renouncing, we got to be careful. There are pitfalls along the way, from disbarment, exit tax, inheritance tax, loss of benefits. We want to retain Social Security should they be eligible. And then, of course, from a life perspective, what if we keep the citizenship? Yes, you can live there 12 months a year. Yes, you can vote in US elections. But outside of that, if there is a fallback citizenship that is fairly powerful in conjunction with the United States, British, Australian, Kiwi, EU, Sing, Canadian, there's a whole litany. What a lot of clients are seeing is, from a life perspective, after I renounce properly, I can still spend 4, 5, 6 months a year there. I can still own real estate. I can still have collect my Social Security, Medicaid, Medicare, pensions, 401ks, when the renunciation is done properly, which I think is, of course, leading to a lot of people deciding that renunciation is a viable option. Now, we'll talk about both sides. We'll talk about Democrats, Republicans, laws that have passed, Trump tax reform, Inflation Reduction Act by Mr. Biden, FATCA by Obama. I always jokingly say, for the poor expat who asks me, who should I vote for to make this better? What side of the aisle? I always jokingly say a third party that doesn't like free money from people who don't vote them back in. So unfortunately, we're going to see how legislation on both sides of the aisle is picking on the US expat as low-hanging fruit in conjunction to tax revenue. We'll look at, what does it mean to be a US person living abroad? Am I a US citizen, which is critical. A lot of times individuals, and this is where as a professional, identifying whether your client is an American or identifying whether their children are American can save you a lot in malpractice, insurance, and payouts, because if you're putting them into a plan not knowing they're US, that can generate a lot of problems. So identifying a problem is the first step in addressing the problem. Have I already lost the citizenship? Don't listen to immigration lawyers. You haven't lost it. There's a difference between immigration and tax law. What are is renouncing right for me? What are the pros? What are the cons? FATCA is how they're catching people. How do we avoid this exit tax? If you don't renounce the right way, they hit you with an exit tax. We want to be an expatriate, not a covered expatriate. Expatriates don't get hit with the exit tax. Covered expatriates do. We'll look at those triggers. The interview. If you're non-compliant, there are amnesty programs. And then, of course, looking at one's relationship with the United States afterwards. So obviously, the foundation of why these issues are important are embedded in the fact that the United States is one of 2 countries on planet Earth that taxes on citizenship. If you're ever on Jeopardy, the other one being the small East African country of Eritrea also taxes on citizenship, which from a fundamental point of view means wherever you are in the world, if you're a US citizen, you're taxed on every euro, peso, pound in life and in death. There is no special tax code for the US citizen born in Canada who never lived in the United States, as opposed to the US citizen born in Manhattan and never left. In fact, the same tax code applies more harshly to the expat because of some of the foreign ownership rules, whether it's corporations, bank accounts, assets. So what's fundamental in understanding why people are renouncing is the fact that the US taxes on citizenship, where you're a resident of a foreign country. Every other first world country taxes on residency. You live there, you work there, you pay. Whereas the US has residency-based taxation, but they also have citizen-based taxation. So with that comes being taxed by 2 countries, expensive returns to file with the US, which we'll look at, the risk of double tax. Many of you will say, but there's a tax treaty in the country my client lives in. A tax treaty is a wonderful tool to avoid double tax when both countries tax. It doesn't help you when you sell your principal residence in Canada or Australia or the UK or just about any other first world country in the world where it's a tax-free event, but the US only exempts the first 250. So when you go to work, resident of Canada like myself, you make $100, the CRA wants 35, the US wants 25. Yeah, the treaty helps. You pay the CRA 35 and you have a credit to offset the 25. But if I were to sell my principal residence here for a gain in excess of 250,000 US, the treaty doesn't help. The CRA says it's tax-free. Uncle Sam says, hey, I'm going to need my 20%. And we'll look at that. And then, of course, death. Filing obligations, taxation in life, estate tax in death. And finding a good time to die is often difficult. When it comes to the US estate tax, you got to go to when you're going to die, what order you'll die in, what year you'll die in, and who will be in power when you die. And we'll look at some of those charts. Now, good. Many of you probably recognize this handsome gentleman, and he's always a good horror story to tell people about, simply because this whole renunciation montage, Boris Johnson gave us, an example of sort of what not to do. Many don't know that Boris was born in New York, and the 14th Amendment would make Boris Johnson a US citizen. He immigrated to the UK at a very young age, 4 or 5 years old. Obviously did well for himself, sold his London flat. To the example that I made earlier about the mismatch in taxation rules, he got stung for hundreds of thousands of pounds on the sale of his principal residence. Boris decided to tell the US government to go pound sand, and not so many words, and that doesn't end well. So when Mr. Johnson was entering the United States, or set to enter the United States, shortly after making those statements, the Internal Revenue Service, at the time he wasn't prime minister, let them know there'd be some guys waiting to discuss his position at the airport. Boris ended up renouncing. They published the names in the Federal Register every quarter of individuals who renounce. You'll see Boris Johnson, you'll see Tina Turner, you'll see Eduardo Saverin, you'll see Nicky Harrison, royalties, a lot of royalty celebrities. Earth tourism was very sexy in the 80s and 90s. It's not as sexy anymore when the tax bill follows you. And what do we learn from Boris? We learn a couple of things. One, a citizen's a citizen, regardless of how young you were when you left. There is no, I'm a US citizen, but. Every time I hear that, I didn't live there, I didn't work there, I left at age 3, means nothing. And the next is, the thing we learned from Boris is, even when you live in a high tax jurisdiction with a tax treaty, which the UK has a wonderful tax treaty with the United States, sale of principal residence, taxable dividends, ETF, lottery winnings, medical expenses, 3.8% Obamacare tax, PFIG, CFC, GILTI, interest in non-US privately held corporations, partnerships, trusts. You will have estate tax, gift tax, generations giving tax. I can keep going, but you're going to have mismatches where the only thing worse than paying a 60% tax rate in a high tax jurisdiction is finally getting a break and having to pay a country you haven't lived in since the age of 5. At some point, you reach a net effective tax rate in the 60s or 70s between the two countries, and you might as well have not gone to work. So Boris teaches us a good example. A US citizen's a US citizen. Hey, the treaty will help avoid double tax and foreign earned income exclusions, but only a high percentage of the time. And all of this was avoidable for Mr. Johnson if he had gotten proper legal advice before. What Boris did is he sold the home and then renounced. What he needed to do was properly renounce and then sell the home. For clients like this, which is pretty much any US citizen living outside the United States who's owned real estate in the last decade, with where real estate prices have gone, you have a Boris Johnson problem on the sale of your principal residence. And what we would do, we would have told Boris, hold on, we'll properly plan, we'll structure, we'll renounce the citizenship at a consulate or embassy on a Tuesday, sell the home on a Wednesday, and Mr. Johnson would be hundreds of thousands of pounds richer today, although I'm sure he's doing just fine. So Boris is a very good example across the world of sort of this US citizenship problem. Now, why is this a problem today and it hasn't been a problem in generations or years before? US citizen-based taxation has been around for, what, 200 plus years? Nothing's changed in the law. What's changed is the ability to find the individuals. And many of you living abroad especially in the sectors that you're working in, are very familiar with the Foreign Account Tax Compliance Act. Put into law in 2010 by then President Barack Obama, a majority in the House, a majority in the Senate, one of the last bills that were passed before they lost those two chambers in the 2010 midterms. And FATCA is a snitching program. 190 plus countries have signed on to require their financial institutions and banks to turn over suspected US citizens, and that data dump is massive. These banks, and many of you probably tuning in from Europe, Canada, Australia, know the challenges and issues for US citizens, especially those with US places of birth. The inability to bank, being treated as a financial pariah because of FATCA, because these banks, if they don't properly identify who their US citizen depositors are and turn them into the IRS, they are financially on the hook. So FATCA is one of the most diabolically successful programs, I think, from a tax point of view, in finding individuals who are not compliant, so much so that many of the first world countries of the world, including the majority of the ones people are tuning in today from, have copied with CRS, which is Common Reporting Standards, where countries are changing information to avoid the dentist in Montreal hiding assets in Panama. Not only the US citizen living abroad in the UK or Canada or Australia or New Zealand who hasn't been filing their US tax returns. So at the end of the day, FATCA is a snitching program. Now, the importance of FATCA is it allows the US government to find individuals at little to no cost. They have dumped the responsibility on the countries and the financial institutions to do it on their behalf. It's diabolically beautiful in its application from a US perspective, in that they sit back, collect checks, while all the other countries of the world and their financial institutions incur the cost to find US citizens. And this is what's driving mass renunciation. This is why we haven't seen renunciations in record numbers prior to 2010. FATCA was passed, took 4 years to get online. Countries haven't started turning over names till 2014, 2015. And many were hopeful that FATCA would be challenged in the courts as unconstitutional and lose. We can put that to bed. Every time it's been challenged, it's lost. The big Super Bowl challenge was in Canada, where we have, 2 million plus US citizens living amongst us of the estimated 8 to 8.5 million US expats living abroad. And the Supreme Court of Canada pretty much, about a year ago, about 10 months ago, 8 months ago, wouldn't even hear the case. They said, this is such a stupid challenge on its face, we're not even going to waste our breath, and this cannot be appealed. So the whole debate and a lot of these groups online, and I won't name names, that I think were selling people a bill of goods, not giving them the full story in hopes of paying legal fees to challenge. And of course, when this notice came out, or this decision on July 13th, these groups disbanded. No refunds, unfortunately, for those who donated. FATCA is not going anywhere anytime soon. And in fact, it's sort of a model for other countries. The Biden administration is obviously, he was vice president during the initiation of FATCA. Recently, we've seen both parties, from Trump's tax reform of 2017 to Biden's Inflation Reduction Act, $80 billion more to the IRS, 87,000 new IRS agents, which makes the IRS now bigger than State Department, FBI, and Border Protection combined. Many believe a lot of this money is going to be used in these agents on the mass data that's been collected on expats through FATCA to then go through and get a return on investment. So we're seeing from both sides, I always jokingly say it's a game of ping pong. The Democrats and the Republicans both have a paddle. One side gets in and whacks the poor expat who's the ball in this metaphor. And then the other side gets in and gives them a nice solid whack. We've seen it with we've seen it with Obama, Trump, and then Biden. So we're not picking on any one side, but when you're $35 trillion in debt, low-hanging fruit is low-hanging fruit. They'd much rather increase tax revenue on someone who doesn't live in a swing state like Pennsylvania or Wisconsin or Michigan, in my opinion. Now, with the obligation of being taxed as a US citizen abroad, the returns are expensive. I'm sure many of you and your clients are feeling this. Paying thousands and thousands of dollars to file tax returns is not exactly a fun start to spring, depending upon where you are, what hemisphere you're in. And, you know, a lot of people say, why? Why is my US citizen friend living in Texas go to TurboTax and spend $50, and I gotta, living in Ontario, pay this guy $3,000 to do returns? Well, it's because of the complexity of reporting. As I mentioned before, the same tax code applies, but when you start crossing imaginary lines with increased reporting obligations, you start to get the, you know, this list here of additional forms: FBARs, 3520s, 8938s, 8621s, non-US corporations, bank accounts, trusts, treaty-based positions. So your buddy in Oklahoma's tax return versus your buddy in Ottawa, similar assets, similar net worth, much larger compliance cost. And a failure to file these forms, because most of these forms, everything but the 1040, can't generate any tax owing. They're just reporting forms. They carry $10,000 penalties for not properly at a minimum per form per year. So for non-compliant individuals facing these massive penalties and then being faced with the option of paying lawyers and accountants quite a bit to stay compliant, even low-income individuals are lined up around the block to renounce, because legal fees and a government fee to solve the problem of 10, 15 grand, or paying a lawyer and accountant and not being able to invest properly and facing double tax for the next 30, 40, 50 years. It's basic math. You're gonna spend that 10, 15 grand to properly solve the problem, and it'll pay for itself 10, 15, 20, 30 times over, plus the sanity, plus the ability of their financial professionals to actually maximize wealth, whether it's TFSAs, ISAs, supers for the Aussies, Kiwi savers, things, corporations, partnerships, PTYs, things US citizens shouldn't have, but for US tax purposes when living abroad don't end well if they do have, and they're leaving money on the table every year, and the compounding value of that lost investment is staggering. So I always jokingly tell people this isn't just a high net worth guy problem. Here in Canada, the wait times to renounce at 5 locations are between 18 and 24 months. And it's not a 2-year wait list because it's all millionaires and billionaires. There aren't enough of them. In fact, it's the common Joe, you know, pensioner, banking on the sale of their home when they retire as their retirement, who doesn't want to cut a check for 300 grand, who's just as motivated as the guy worth 15, 20 million staring down a US estate tax and death on top of the income tax issues in life. Now, for those who haven't been filing, there are amnesty programs. Now, we don't have time to go over these in our limited session today, but we help more expats get US tax compliant and renounce than any other firm in the world. So you're facing these $10,000 penalties as a non-compliant person, but if you go to the IRS before they find you, you can do 5 years into a streamlined process while renouncing. The other 30 years is water under the bridge, full abatement of penalties. It's a very, very good program. The delinquent informational return submission. There's a relief procedure. Now, we don't have time to walk through these individual amnesty programs, but the moral of the story is, for those who have not been flagged by the IRS yet as non-compliant under FATCA at the border, you know, people with US places of birth get absolutely hammered. There are amnesty programs to enter into. So it's not like if you've been living abroad for 40 years and haven't been filing, you're facing, you know, $500,000 in penalties and you need to file 30 years of tax returns. No. If you go to the IRS before they find you, and under these amnesty programs, penalties are down to 0. If you want to renounce, you only have to give them 5 years, not 40 years. And usually what you'll find is the math on it will, in 99% of situations, point to a renunciation being economically in the client's favor. So what you'll do is you'll go into the amnesty program, backfile the 5 years to solve the last 40 years of non-compliance, while at the same time properly renouncing and avoiding disbarment, exit tax, inheritance tax, loss of benefits, travel restrictions, come out the other end treated like any other citizen of your fallback passport, for which you could work, live, naturalize, and even become an American again if you wanted one day. Although I've never had one in, I've done over 5,400 renunciations. I've never had someone want to naturalize it back. But these amnesty programs work to solve your historical indiscretions, while at the same time, if you're properly renouncing, it solves the next 40 years of potential compliance and double tax issues. And again, we help more people than anybody in the world accomplish those two goals. Now, there is a relief procedure, which was recently announced in 2019. I was speaking in Windsor on this at a panel, and a couple of the IRS guys came right before COVID, and the IRS guys came out, we're passing a relief program. So this relief program, not only do you get the full abatement, not only do you not have to file for 30 years like Streamline, but if you're willing to renounce and qualify, if you owe tax on those 5 years, there's a $25,000 credit. Now, I don't think this program will be along forever, but this is another olive branch for individuals looking to renounce and who have not been filing returns. You know, a $25,000 credit to offset any tax liability is quite nice, but you only get the 25 grand credit if you qualify for the program. And to qualify for the program, one of the criteria is you have to renounce. Now, it does feel like they're sort of incentivizing, the service is incentivizing people to renounce, but I don't ask questions. We just follow the rules. Again, a lot of clients, you know, living abroad think they're not involved in the US debt that they're telling you is 34 trillion, which is probably a whole lot more than that. You know, recent numbers have it at about $264,000 per tax-paying citizen. Clearly, there's some money that needs to be generated. $80 billion on top, 87,000 new agents. I'm sure we're trying to get that number down. They can also flag you at the borders. Many of you probably know of the passport revocation programs that, you know, are often used at the border. Poor Canadians get slaughtered with this. In essence, they say, you know, they show your Canadian passport. It says born in Georgia on it, and you get the old welcome home. And there's a rule that says under 8 USC 1185B, you have to travel in and out if you're an American on a US passport. And of course you get yelled at, and then they yell at you to go get a passport. And now for the first time with a passport, you have to get a social security number. And now you're on the grid for social security number. And that's how you file a tax return. And if you don't get a social, you've just put an application in under oath saying you're American and where to find you, and that you don't have a social, which means you've never filed a return. So they try to, if you owe more than 50 grand to the IRS, there's a passport travel confiscation program. If you don't have a social security number, that's the rule there, putting you in the same soup as someone who they flagged and owes money. So whether it's FATCA, whether it's travel, whether it's banking, the information sharing, the paperless systems that all governments are going to, I always tell people, unless you're going to live in the woods, it's virtually impossible these days to be under any kind of financial system or banking system and not be uncovered. Now, that's how the US taxes, that's how they're catching people. This is why people are renouncing. A big question that I get all the time is, am I American? Are my children American? Are my grandchildren American? And luckily, the American Bar Association has a very clear chart. It's one of 3 pages long, and it has I think a 320-page legal treatise. Obviously, I'm being facetious. It seems so obvious. Are you an American? Yes or no? How would you not know? But most people, I wouldn't say most people, a lot of people don't. A lot of people don't know they're American, or a lot of people thought due to rule changes or what they were told at the time, they're no longer American. Here's a nice cheat sheet, and especially for individuals in financial institutions subject to the FATCA rules, this is a bit of a scripture that I provide to them to say, look, you are financially on the hook to identify whether your client is a US person, whether that's under FATCA to the Internal Revenue Service and massive penalties for non-compliance under FATCA from a financial institution perspective, or to the client themselves, putting them into, you know, butterflies or estate freezes or ETFs or mutual funds or TFSAs or corporations, and all these wonderful tax planning techniques across countries around the world that if you are not aware that they're American, you can be walking them into massive, massive penalties and US tax. So there's two ways to become an American. You either are born that way or you become one in life. And I always say if you become one in life, you remember it. There's usually a swearing in ceremony. They wave American flags. Everybody goes out to lunch, shakes your hand. You remember it. Not everyone knows they're American from birth. And 98% of the time, this chart is what you will need to use to identify if your clients are American, even if they don't think they are. Number one, if you're born in the US, you're a US citizen. So when your client born in New York says, oh, but I left at age 3, don't worry about it. Yes, worry about it. The 14th Amendment is very clear on this, whether you spent 30 seconds and were born in the US or you spent 30 years having been born in the US. Second, 2 US citizens give birth to a child outside the United States. I was born in Pennsylvania. My wife is born in Georgia. We've come to Canada, had 6 children, all of them born in Alberta. Every single one of them are American, just like if they were born in Texas. They were born to 2 American parents. 3, US citizen parent, non-US citizen parent. 3A is the Meghan Markle, Prince Archie, Prince Harry. For the first time in history, the US government has claimed to tax a member of the royal family. Why? Because baby Archie, I was giving this presentation at the Savoy in London when old Archie was born. He was born in the UK. His father was clearly not American. His mother was. She had previously lived in the US 5 years, 2 after her 14th birthday. And Archie was born in the UK or outside the US after November 14th, 1986. And the rule is if the US born to a US citizen parent, non-citizen parent outside the US after November 14th, 1986, you are just as American as someone born in Texas. If your parent, the US parent, could be mom or dad, in this case it was mom, previously lived in the US 5 years, 2 after their 14th birthday. Now, if the child is born before November 14th, 1986, then the parent needed to live there 10 years, 5 after their 14th birthday, when you have 1 US, 1 non-US, born on non-US soil. So you have to go through this. Now this artificial insemination, adoption, those are sort of back in the chart, but 98% of the time, if one of your clients answers yes to 1, 2, 3A or 3B, and it's very basic, right? Hey, where were you born? I was born in Toronto. Hey, where were your parents born? Pennsylvania and Ontario. Hey, did your one parent live in the US from birth until age 19? Yeah, I lived there till 25. You're an American. Again, it doesn't matter if you haven't gotten the passport or the social or the certificate. Those are simply identification documents. You can be an American citizen and not have a US passport, travel document. So again, be very, very careful. And again, the onus is on the financial institutions. You'd be shocked how many times I get calls from financial advisors going, oh my goodness, save me. I put my US citizen client into a wonderful Canadian, British, Australian play for his family and their succession planning. And I just found out I walked them into a mess for US tax. I didn't know they were American. I didn't know, even though in the file, it says their place of birth is Florida. Usually it's time to call our malpractice carrier. Have I already lost it? We won't spend much time on this, but you will read online and I will get 1,000,006 questions saying, I did a magical act. I became a British citizen in the 70s and they told me I lost it. Because yes, the US didn't allow dual citizenship until the early 90s. Bill Clinton waved a magic wand and now you're back in the mix. Please do not listen to immigration lawyers on tax. Please do not listen to accountants. You want attorney-client privilege, in my opinion. Please be very careful of people preparing tax returns who are CPAs licensed in Illinois. Illinois is the only state in America where a Canadian or non-US accountant can fly down, take a 100-question multiple choice exam, and they are an Illinois CPA having never taken a single class or test, because the test is only on ethics. Here, we have US lawyers, US CPAs, Canadian lawyers, and Canadian accountants at our firm. I fly down my Canadian accountants to take the test too. But when they get a US question, they head down the hall with 20 other people who have actually educated, born, practiced there. Be careful. Same thing with Massachusetts. It's the only state where you don't have to take a bar exam if you're a Canadian lawyer or a non-US lawyer. You show up and take an ethics exam and now you're a Massachusetts lawyer. Be very, very careful. And yes, you're going to read online, under the INA, you've done this magical act and you're not American anymore. Yes, you are. The IRS was very clear on this. Don't send me an email that says I found out I'm not American because I did this act. Yes, they may have told you you weren't American at the swearing-in ceremony. Bill Clinton brought you back in, sorry. And when they were passing FATCA, shortly before it in the amnesty programs, the IRS released IRC 877 Cap AG4, which put to bed any ambiguity, because what they didn't want is to spend billions of dollars setting up a worldwide dragnet among 190 countries to find non-compliant citizens, to have every single person they caught say, oh, by the way, yes, you caught me. I was born in Kentucky, haven't filed, but 30 years ago I did some magical act under the INA and now I'm not American. You don't get any money. Everybody would do that. So the IRS was very clear. You've lost your citizenship on the earliest for tax. When you renounce, deliver a statement of renunciation, have a certificate of loss. So 30 years ago, when you did that magical act or became a Canadian or a Brit or an Aussie, did you fly to DC and get a certificate? No one did. So unfortunately, you'll have clients who will tell you, they'll look in the file, hey, are you American? No, I'm not American. You open up the file, you're born in California. Oh, yeah, I left 30 years ago. Well, it didn't stay with you, it came with you. So you have to be very, very careful. Now, in reference to the pros and cons of renouncing, let's look at what I'm seeing every day in reference to renouncing. What are the pros, what are the cons? Loss of protection abroad matters very little to most. Consular services, not many people renouncing are too jazzed up about losing consular services. Yes, you can't vote in US elections, but there's an argument among many of my colleagues that when you live abroad and states' rights and how they count absentee ballots, does your vote really count? That's a discussion for another day. Access to the US job market for my youngsters coming out of university, 18, 19, 20, 21, 22 years old, having a passport and a social, you can work there tomorrow. Especially for my Canadians who, with that passport, I could get you a USMCA work permit in 2 weeks after renouncing. I actually renounce people who have job offers in the US with a Canadian passport because it's so easy to get that work permit and they know they're going to come back. And what doesn't follow you to tax you when you come home is a work permit, whereas citizenship does. So it's something to think about. Further on in your career, if we renounce properly, which we would, you're treated like any other citizen of your fallback passport. We can get a work permit, a visa, a green card. Hell, you become American again. Treated no better, no worse. Travel to the US. If you need 12 months a year in the US, renunciation isn't for you. But quite frankly, for many expats, it's not even an option whether you stay American, because paying for healthcare in your golden years is quite difficult. Giving up that socialized healthcare in the country you've been living in and paying into can be a challenge. But again, when we're done, you can still enter on a visa. Canadians are exempted from visas. Spend 3, 4, 5, 6 months a year, depending upon the facts, but you can't spend 12. Why are people renouncing? It's all financial. Cost to file. I mean, I run a law firm which has an accounting wing which does tax returns. And quite frankly, when somebody says I don't want to renounce, it's in my financial interest. I'm going to charge you $3-4 grand a year for the next 30, 40 years to file your returns, plus new administrations in both countries will come in. You'll need will work, married to non-US persons, US persons, the kids. You go from a 10 grand client to solve this problem for life to a 300 grand client over the next 30, 40 years. So the only thing worse than paying the lawyers and accountants to fill out all these forms every year and deal with the headache and hassle to boot is the double tax. Is saying, hey, I did your return, here's a 3 grand bill, and oh, by the way, your financial advisor shouldn't have put you into those PFIGs, those ETFs, those mutual funds, and you owe another 20 grand. Not ideal. And then, of course, you get out of these funds. You don't invest in the TFSAs. You don't invest in the Kiwi Savers to avoid the accountant saying you owe tax, and now you're losing out on money. Compounded over your life is massive. And then the estate tax. The US has an estate tax. When you die, they add up everything in the world. If you're tuning in from a low tax or zero tax jurisdiction, my Saudi, my UAE, my Caribbean residents, no brainer to renounce. High tax jurisdictions with estate taxes, inheritance taxes, UK, Canada, Australia does not, New Zealand does not. Avoiding the US estate tax can be huge. And there's a lot of uncertainty around where the estate tax exemption will go, because the way the US estate tax works is when you die an American, they add up everything in the world you die with, and every dollar above, or excuse me, there's an exemption amount, and every dollar you die above the exemption amount of fair market value of your assets is taxed at 40 to 65%. Now, we're under the Trump policies, which are 13.6 million, but most Democrats are 1 to 2 million, and most Republicans are about 2 to 3, 2 to 5. Now, the Trump policies expire January 1, 2026, regardless of the November outcome. Mr. Biden has always wanted a $1 million exemption. So for clients living abroad, especially those with no estate tax in the country they live in, if you're worth 4 or 5 million, you die and the exemption's 2. 55% of 3 million to die on money you've already paid tax on in life is a tough pill to swallow. So as I mentioned before, the US estate tax is very easy to plan for. You need to know when you'll die, what order you'll die in, when you'll die, and who will be in political power when you die. And you can see the last 20 plus years of an exemption as low as 675 grand or Donald Trump's 13 million. You got to pick a good time to die. People who don't have to worry, people who properly renounce and don't die American. Trump, again, we picked on Biden, we picked on Obama, we're going to pick on the Donald. His tax reform, he was the most Republican that ever Republicaned. He had US tax reform in 2017, could have fixed this whole problem for expats. In fact, these online groups were begging him, wave a magic wand and stop all of this. Of course he didn't. Neither party is. They're just as guilty. He actually made it horribly worse if you're a US citizen with an interest in a non-US privately held company. Transition tax, guilty tax. We could spend 2.5 hours just talking about those tax regimes. We won't, but this just shows that both parties are giving it to you. Election coming up, a lot of clients calling, what should I do? Who am I rooting for? To be honest with you, I don't care who you politically affiliate with, but here are the facts. Trump is a low tax policies, right? You can look at the comparisons between the two, 37%, 39%, capital gains, 0 to 20, over $1 million, 44% under Biden is what he would advocate for. The estate tax is massively different. Corporate tax rate of 21 versus 28. Joe Biden actually and Donald Trump never get along, but the only part of Donald Trump's tax reform from 2017 that Joe Biden wants to keep is the guilty tax on US citizens living abroad who have interest in non-US privately held companies. The poor doctors, dentists, and lawyers outside the US, or businessmen or businesswomen. One of the worst facts you can have is being a US citizen with a privately held corporation, non-US corporation. You get slaughtered. Between the legal fees, CFC, guilty, PFIG, transition, they agree on next to nothing except, yes, the guilty tax to tax the expat. So why the drastic increase of people renouncing? It's all tax related. The stress, the headache, the hassle, the legal fees. Here are the numbers. I like to see them of the publications of individuals who've renounced in relation to when offshore disclosures, FATCA went online, COVID obviously affected. What these numbers don't show is the massive wait times to renounce. 1.5 to 2 years in Canada. London's a year plus. Sydney's a year plus. Bern's a year plus. The wait times are staggering. Where can you renounce? Well, you've got some Canadian locations, long wait times. We forum shop and help people renounce all over God's green earth. I have a list of 60 plus places where we could get out on 6 continents broken up by country. I'm flying people in long wait times all over to renounce in 3 or 4 months, not 13 to 14 months. Now, if we decided we want to renounce, the exit tax is a big issue. When someone renounces or terminates a US green card, long-term permanent resident, the US government attempts to impose an exit tax. Now, there are triggers of the exit tax. 1, worth more than 2 million. 2, paid more than about $1 million in tax over the 5 preceding years to the US, not to the country they live in. And they need to certify on Form 8854 that they're 5 years US tax compliant. Obviously, avoiding this exit tax is very important. We don't have time today to run through all the criteria, but the 2 million is done under gift tax. It's not inflation adjusted. It's been 2 million since 2008. It's one of the few numbers that is not inflation adjusted. In fact, B is inflation adjusted, and they purposely don't inflation adjust A. Just by waiting every year, it gets harder and harder. 2 million in 2008 was a different 2 million than 2024, I'll tell you that much. But again, how that's valued, planning, ways to avoid the exit tax, even if you're over the 2 million. We help clients all the time do that. And then, of course, you have to certify that the 5 preceding years are in good working order. That's why if you haven't been filing, if you want to renounce, we do 5 years and then renounce. If you want to keep it, you do 3, but you have to keep filing for the rest of your life. If someone tells you you can't do 5 years into streamline, you got to do 3 years and wait 2 years to renounce, walk out the door. They don't know what they're talking about. If somebody says I need to renounce and I need to file tax returns and says you should do the tax returns first, walk out. They're wrong. In fact, I could renounce you tomorrow and I'd have till June of 2025 to get your 5 years in. And in fact, from a strategy point of view, you want to stop the bleeding and clean up the mess along the way, not the opposite. You don't even know what years to file until you know when you're renouncing. So if someone needs to renounce and needs to do tax returns, start the renunciation first. Actually, we start them at the same time. That's where the real value in planning comes in. Now, there are some exceptions. If you're 18 to 18 and a half, you can't renounce under the age of 18. Or if you meet the dual at birth exception, A and B are exempted. You could be worth $100 million if you meet 1 or 2, but 18 to 18 and a half is a niche market, and most of you will not meet the dual at birth exception. It's being a US citizen and another citizen of another country the first breath you take, not a month later when registered, or 6 months or a year. If we have clients, again, we do more of these than any firm in the world. I've done over 5,400. If we have clients who are lucky enough to be dual at birth, we better have that full opinion. There is no take back with renunciation. If you screw it up, you screw it up. You can screw up tax returns. The IRS will slap you on the wrist. You can pay somebody to amend it. When you screw up a renunciation, there are no take backs. So you better be damn sure. Now, for some of you saying I'm worth more than 2 million and I know I'm not dual at birth, am I hooped? No. This is where the Trump policies make it the best time in history for high net worth individuals between 15, I'd say 3 to 20 million, where we can get out through proper planning and pay nothing. That's never been the case before. This is where the discount valuations, the gifting, the restructuring, staggered renunciations, I renounce mom and dad, just mom, mom, dad, all the kids, the grandkids. We'll do 8, 10 people of a family all at once. We'll get them appointments all at the same day. Maybe we fly to Europe to renounce for a nice renunciation vacation, or the Caribbean. But either way, there now is a wonderful opportunity to plan. Of the 5,400 people that we've helped renounce, which is probably 5,200 more than anybody in the world, 95% of those clients, we avoid the exit tax. Now, the 5% we'll talk about in just a little bit. Again, part of renunciation, we'd be doing your returns, or if someone else has, we have to review them. You swear under penalties of perjury to their correctness. The IRS has been very blunt that they will be reviewing those after you swear under penalties of perjury to stand next to them. As a last bite of the apple, you can see here what Mr. Cooper said as part of the IRS Criminal Investigation Unit on renouncers. Now, the interview. The interview is obviously something that gets people jazzed up. Preparation for the interview, we've, again, done over 5,400 of these, and I prep every single person, depending upon where we're going. If you go into this interview and the report is written and you sent to the U.S. Attorney General and they determine you're doing it to avoid tax, you're blacklisted for life. We've never had one. We prep the right way. We do not lie in the interview. You are under oath, but you will and need to say the right things, the right truthful things. And this inadmissible list, it's a little intense. People that are blacklisted from America on this list include drug traffickers, terrorists, Nazis, child abductors, sex traffickers. A few down from the Nazis is people who renounce to avoid tax. Now, you try to laugh a little bit about it, but obviously it's very serious. We have to make sure that the interview goes well so that you are treated like any other citizen of your fallback passport and can enter the US at your leisure. The government fee is $23.50 US. It used to be $4.50. Yes, they have asked the US government to lower it, and they've done nothing. I wouldn't hold my breath. In the interview, you will actually sign off agreeing that if the US Attorney General determines that I'm doing this for tax, I agree. And then it gets sent off for the determination. You'll sign it, a vice consular will sign it. You need a certificate of loss of nationality. If you thought you did some magical act 30 years ago and you're not American, if you don't have one of these, you still are. This is what we get with a proper renunciation to solve your banking and taxation problems. Now, I know we're running a little bit low on time because we wanted to keep the last 5 or so minutes for questions, but all these wonderful facts that we've run through for our citizens also apply to green card holders. You may have seen that the US exit tax has those triggers for US citizens renouncing and green card holders, long-term permanent residents, who are looking to give up their green card status. Now, we're providing these slides for information for everyone. Obviously, we're not going to muscle through them all. But remember, for green card holders, just because the green card expires doesn't mean you're not taxed. Just because your US passport expires, does that mean you're not a US citizen? Of course not. You need to renew a piece of plastic. When a green card gets taken at the border, does that mean you're not? No, that means they took the plastic. We have to properly terminate the card. We have to backfile if needed. We have to avoid the US exit tax. The only difference between a green card termination and a renunciation of citizenship is no interview. So you don't have to go to a consulate or embassy and be grilled. And no $2,350 US government fee, which is quite nice. Earlier we were picking on Boris Johnson, the poor Brits. They went from a prime minister who was a citizen to a prime minister, their current prime minister, Rishi, who is a green card holder. And when the press got a hold of this, he was very open about the fact that he was not going to make the same US tax mistakes of his predecessor, and said, look, it's being handled. I'm fully tax compliant, which, you know, hopefully the Brits can pick someone who isn't taxed by the US to run the country. Myths about renouncing. Again, we're trying to be treated like any other citizen of our fallback passport when this is done. Can you still collect Social Security? Yes. It's a common misconception. Oh, I'll give up my Social Security. No. If we renounce properly, you collect every cent, get rid of the bad, keep the good. Can I still have my retirement accounts there? 401ks, IRAs, Roths? Of course you can. Can I still own US real estate? Yes. They want you to own it. Believe me, come there, spend their money, spend your money. They want it. If I renounce, does that get my kids out? No. It doesn't. And no one can renounce for anybody else. You have to be 18. You lack the consent under 18. And you can't have any mental cognition issues as well, even if you're over 18. Dementia, Asperger's, autism. We deal with a lot of those issues in trying to get over that hurdle. But obviously the objective is to be treated like any other citizen of your fallback passport when we're done. If anyone ever tells you that after you renounce, you have to file tax returns for 10 years, and I get this all the time. I mean, the main reasons that we do these presentations is one, stay off the internet. The internet is horrible for advice on renunciation. It's a dog's breakfast. You'll be wrong every time. You need 8 different jurisdictional areas of law, and they don't even answer one right. 2, there's a ton of professionals who claim to be experts who will tell you stuff like this. Oh, after you renounce, you have to file for 10 years after. No, you don't. That stopped being law 15, 20 years ago. The day you renounce at that consulate, the day after, you're tax-free. Die, win the lottery, sell your house, sell your corporation, incorporate, do whatever you want. So again, do not listen to someone who tells you you have to file for 10 years. I know we're pressed up against time. We won't go over the summary. We got a bunch of additional information for individuals. I always say if you want to fall asleep, tax articles are the best thing to read. And again, we help more people go through this process than just about any firm in the world. You know, our fees legally $23.50 US. Our fees range between 10 to 15 grand Canadian to renounce someone, some less, some more. You got to backfile tax returns. You can spend another 10 grand, 15 grand doing 5 years of returns. But the question is spending that 20 or 25 grand better or worse than being double taxed for the rest of your life for decades to come and generationally? And like I said, 99.9% of the time, economically, renouncing makes more sense than keeping it. Emotion factors in, but that's something we always discuss with the client. So I think I'm a little bit over time, and I apologize, Dan, but I will kick it over to you because I know we wanted to keep the last 5 minutes for questions.
Thank you very much, Alex. I think you're exactly on time. And just before we go into the Q&A, thank you very much for that presentation. Some really interesting information, some stuff I didn't know about our sort of recent leaders as well. So that was very interesting to hear. But we've had a few questions in. Should have time for at least one, perhaps two. I'll read these out for the audience. You should be able to see them, Alex, on the toolbar as well. We've had a question from Peter. I was born in the US and moved to Canada when I was 3 months old, and then became a Canadian citizen and have been a resident in Canada for over 60 years. I have and continue to maintain a Canadian passport. I own no assets in the US and rarely visit, only for vacations. Am I at risk of any tax implications?
100%. You are an American citizen. You're sort of the poster child for, hey, we have Canadians who the only time they were in the US, let alone left at a young age like yourself, Peter, 3 months. We have Canadians who the closest hospital just happened to be across the border in Maine when they were living in Quebec. And they were there for 3 days, not 3 months or a couple of hours. You're a US citizen. We need to get you tax compliant under an amnesty program, almost certainly renounce the citizenship from an economic point of view. But yes, if the IRS were to flag you and under FATCA, you've got a US place of birth. It's going to be a matter of when, not if. You've probably already been flagged by financial institutions or traveling on across the border with your US passport that says born in whatever state you were born in. 100%. You are the poster child of someone who needs to get into amnesty, almost certainly look to renounce. Feel free to shoot me an email. I can send you the much longer version of this webinar for Canadians. It's 2.5 hours. It really dives into the options for someone like you. But, the bad news is, yeah, you're just as American, no different. Whether you were born there and spent 3 months or 30 years, you're in the same soup. The good news is there's programs and solutions.
Brilliant. Thanks for that, Alex. And we have a similar question in from Linda. And actually, I think probably the best thing to do, Linda, would be to reach out to Alex to have that question answered, just looking at the time now. I would like to sort of finish, Alex, and I don't know if you have any thoughts just looking at that question initially, but just to finish on asking you just for your final thoughts and any closing comments that you would like to make for today's session.
Yeah, no, I mean, it's, in reference, this is an issue that everybody needs to look at. What we do is we'll have consultations where we'll go through these exact fact patterns and we'll weigh the pros and cons. You and I, myself and the client will sit down for an hour, answer your questions, tailor it to your specific facts, and let you decide. Because there's the emotional component and then there's the economic component. And if you can, get those two answered, the decision is very clear. I know there were some other, how does it affect my federal pension? Yes, you can keep every penny of the federal pension. There were some questions about, account fees far exceed the tax owed. Is there a simplified tax submission? No, you're a UK resident. That's why, submitting a UK tax return is mindlessly simple. A US one's going to cost you thousands of pounds. That's why, for 8,000 pounds, we can solve the problem, get you into London, Brussels. I saw Linda's question, by all means, Linda, feel free to email me, but, we're here to help anybody with any questions, concerns. I know it's like drinking out of a fire hose to start, but if anyone's interested, reach out to myself. We can send materials, microsites, articles, a much longer webinar, again, 2.5 hours on these topics, just diving into detail, and happy to work with anybody who would want it.
Brilliant. Thank you, Alex. I know we've had a few requests for your email address. We will be in contact with everybody that joined today with a follow-up that will include Alex's contact information. So please wait for that. That will be with you tomorrow. But Alex, once again, thank you so much for today. It was a pleasure to spend an hour in your company. Really vital information, I think, as well. And thank you, of course, to our audience for being with us today. We really appreciate it. I wish you all a lovely rest of your day. Goodbye.
Hi, thanks everybody.